So in the next clip, Mnisi Unfiltered, okay, he responds to Baloyi'S request to add the 13 photos that they found with regards to Ubongani Danzi from the pile of 700 and the 3 photos that they found with regards to Umtobisi Mncube, accused number 3, remembering that they said he has the dreadlocks, the big eyes, and the gold tooth. And they found the photo with the gold tooth, and when they pointed it out, Mnisi during cross-examination said, that is not accused number 3. That is accused number 3's brother with the gold tooth. You have made a wrong assumption. So now you understand why the state had to go back and dig through 700 photos to find something that would work with their narrative, which is accused number 3 is the one who entered the Kumalos. Yes, is the one who entered the Kumalo home, along with accused number 2, Ubongani Danzi. I find it very convenient that the photos that they found are only with reference to the 2. Nothing extra, no extra photo with the others, accused number 1, number 4, and number 5. No, it's just the 2. Someone said the local inspection in local should also include the hostels, the Basutini hostel and the George Cork hostel. And I agree, okay? I agree. Unfortunately, nobody put in that application. Why? Because Umshalolo was not there. Hopefully, it's still going to be requested. We don't know. But I digress. So here's the thing. Baloyi needs those photos on the record. We don't know what the photos are. Although he snuck it in, okay? He snuck it in during the re-examination of Gininda. He got to beam it up and the defense said, you have got to be kidding me. No, that's not how it works, okay? You've got to finish your re-examination because you can't just re-examine. There's even an RE between the exam. It means you're doing it again. You can't re-examine Gininda and then add a photo that nobody has ever seen, and then you close your re-examination and that's the end of that, meaning the defense will not have had a chance to cross-examine. And they say Baloyi is a senior prosecutor. Wow. I don't know. Ever since the whole LPC situation, I've been very cautious. Because what do you mean the LPC can duplicate records, FFC numbers? Now we have Senior Baloyi just suddenly introducing a photo, beaming it up, expecting the defense to be asleep at the switch? What was he thinking? I think that there's a lot of games that are being played here, a lot of mind games, and it's very unfortunate. But let's go ahead and listen to Advocate Mnisi break it down, his response to Baloyi's heads of argument. And let's see what happens at the end of that. Okay? Yeah.
I will start with the last aspect on the footage. We would request that even before that footage is made available for purposes of the proceedings, request that the state should disclose it to the defense, and I'm saying that on behalf of accused number 1 and 3, so that we can go through that footage with a view to prepare meaningfully our defense with regard to that piece of evidence. The state is well within its rights to request an indulgence from the court to open its case in an event new evidence that is relevant comes forward. That will be up to what the court will decide. This court will have a discretion in that regard. That is my submission with regard to the last aspect. On the application that has just been moved by the state, the issue indeed has been canvassed yesterday. Just to give a bit of a background, the state indicated that he indicated when he gave us the photos that he
Who doesn't hear me?
The state indicated that it had communicated to the defense that it would want to use these photos in re-examination. That was an address from the bar. That is soon after the state had beamed a photo of that picture on the big screen, and then I stood up and I raised an objection and indicated that this would constitute new evidence. That is when the argument about the fact that there was a discussion between the state and the defense that would be canvassed in re-examination. Apparently that information was not, or that submission was not supported by the defense counsels. In an endeavor to support that submission, the state then went to what I would call an email message that was purportedly sent to the defense. He read out that message to court, and the message did not confirm what the state said, that he indicated to the defense that he wanted to raise that message, that issue in re-examination. So I'm not so sure how the issue was then resolved, but the impression that was created to me was that in any event, that picture that the state sought to lead constituted new evidence, and the state needed to bring an application or indulgence to reopen its case in order to introduce that evidence, such that it cannot be introduced.
Sorry, you're saying the state, wait, sorry. You're submitting that the state should reopen its case.
No, I'm saying the
You
state.
never said that.
I'm saying the state should make an application, request the court's indulgence to reopen its case for the introduction of that new evidence. It cannot
The state has not closed its case. That's factually the situation now.
Yes, my lord.
Yes.
I'm talking specifically with regard to this new evidence. I'm saying the state cannot introduce this new evidence in re-examination.
Fine.
Yes. Now, the state today brings this application to be allowed to re-examine also on the basis of this new evidence. We have objected yesterday, and we indicated the basis of our objection, my lord. Now, when one looks at the heading of the state's application, it reads, "Heads re-examination of Brigadier Kininda on the additional photos of accused number 1 and number 2. Now, immediately the state concedes that this constitutes new evidence. State refers to Exhibit S. The photos that the state wants to re-examine Brigadier Kininda on are photos that are not contained in Exhibit S. When the state went through the downloads of accused number 1 as per of accused number 3 as per the allegation, there were more than 700 photos that were found in the downloads. But then the state, in the presentation of its case, then decided to identify certain photos and compiled Exhibit S, which in its view was enough to come and present its case based on that particular evidence. The state also indicates on paragraph 3 that the reason why such evidence was not led in examination in chief was because they were able to identify further photos at the time at which I was afforded the opportunity to go and read that very big record of proceedings. They were able to identify those extra photos, and they now want to introduce them through re-examination. Our view is that is unprocedural, my lord. As much as we admit that we realize that there's nothing that is stopping the state from adducing that evidence, but that evidence cannot be introduced through re-examination. Procedurally, the state needs to finalize its re-examination, made an application to the court for the leading of this new evidence, which is to be contextualized in its case. Now, the issue with regarding to the photos, I just want to contextualize this. Based on the extracts that the state referred to, there was a point when I cross-examined Brigadier Gininda, and I took him through his affidavit, the affidavit that he brought, that he prepared for the application of the warrant of arrest against accused number 3. Now, in that affidavit, he mentioned, amongst others, that the suspect who got into the house, who had a gun in his possession, had dreadlocks, had big eyes, and had a golden teeth. Now, with that description, I then requested Brigadier Gininda to assist this court by referring to the compiled or to the prepared Exhibit S in its entirety, on all the photos that were contained in Exhibit S, and identify these traits or these marks which he alleges in his affidavit that they match accused number 3, which were the dreadlocks, the big eyes, and the golden teeth. He then started to page through Exhibit S. As he was paging through Exhibit S, he came across a photo of a person which had a golden teeth. And then he said there was accused number 3. When I took instructions from accused number 3, I'm not so sure whether I put this on record. Accused number 3 then said to me, yes, this is my younger brother or elder brother or something like that. But that was after Brigadier Gininda had said, no, this is what is being referred to in my affidavit, that this is the person who had a golden teeth. And indeed, the person who had a golden teeth in Exhibit S was there, and accused number 3 said this was my younger brother or something like that. I'm speaking under correction in terms of whether it was an elder brother or a younger brother, my lord. Now, that was basically the essence of this identification in terms of Exhibit S. Now, there was closed. These photos that the state would then want to lead this evidence on now are not part of Exhibit S, and as such were not referred to in Brigadier's evidence in chief. As such, Brigadier Gininda was not cross-examined on them because they were not part of Exhibit S. It never anticipated that at some stage in the future the state would then come and use them. We don't say, if the state says, yeah, no, we now deem them to be relevant, we want to use them. That is their discretion. But the point that you are mentioning is that Brigadier Gininda cannot, or the state cannot introduce that evidence through re-examination. As I've said, the state would have to close its case, finalize its re-examination on Brigadier Gininda, request an indulgence for the court to introduce this new evidence. That it will be outside our ambit. That will be the duty of the court with the discretion that it will have to exercise. We understand that the state's case has not been closed. That would have happened even if after the state's case was closed, my lord. All that we are saying now is that this information cannot be introduced through re-examination. It must be introduced by virtue of examination in chief, and we be afforded the opportunity to cross-examine Brigadier Gininda. Otherwise, the procedure that the state wants this court to embark upon is very precarious, my lord. And I realize that the state says, let the court allow us to re-examine Brigadier Gininda also on this additional information. That will be wrong. We realize that the state is saying, let the court allow us to reopen our case, to reopen our examination in chief, so that we lead Brigadier Gininda on those photos. That is in the discretion of the court, my lord. Whether the reason that they've submitted or not are sufficient, it will be for the court to decide. That will be my submission.